Perhaps judges need no longer wait for retirement to join the RSS. In a nation that prides itself on the rule of law and the impartiality of its judiciary, recent developments raise profound questions about the line between governance and ideology. What happens when the guardians of justice are drawn into the folds of political organizations? Welcome to this in-depth analysis of the Madhya Pradesh High Court's controversial judgment lifting the ban on civil servants joining the Rashtriya Swayamsevak Sangh, RSS. To understand the controversy, let us revisit the history. Rule 5 of the Central Civil Services, Conduct, Rules, 1964, prohibits government servants from associating with political organizations. The rule was designed to ensure neutrality and prevent bias in public administration. Among the organizations banned for civil servants were the Rashtriya Swayamsevak Sangh and the Jamaat-e-Islami Hind. Both claimed to be cultural and religious entities, but were viewed as inherently political by the government of the day. Fast forward to 9 July, 2024, when the central government issued an office memorandum removing the RSS from this list. The rationale? According to the Madhya Pradesh High Court, the earlier inclusion of the RSS was a mistake. The Madhya Pradesh High Court not only upheld the government's decision but went a step further, describing the inclusion of the RSS in the 1966 ban as unwarranted and lamenting the delay in correcting this mistake. The court questioned the basis of the ban, asking for empirical evidence or compelling studies to justify it. But what does this judgment signify? The judgment appears to conflate the criteria for banning an organization under the Unlawful Activities Prevention Act with the more straightforward principle that government servants must remain apolitical. This is a dangerous precedent. The RSS claims to be a cultural organization, yet its political activities are undeniable. It has fostered numerous affiliated bodies, including the Bharatiya Janata Party, its political wing. The Madhya Pradesh High Court itself acknowledged that a minority of the RSS's activities are political. But is that acknowledgement enough to justify its exclusion from Rule 5? The agenda extends to education as well, with RSS-run schools promoting a version of history that aligns with its ideological goals. Can civil servants truly remain impartial while associating with such an organization? Another glaring issue is the selective application of the ban. While the RSS has been exonerated, the Jamaat-e-Islami remains under scrutiny. The court did not demand similar evidence or studies to justify the continued ban on the latter. Why this double standard? Judicial independence is paramount. When judgments appear to align disproportionately with the ideology of the ruling establishment, the credibility of the judiciary itself comes into question. The implications of this judgment extend far beyond civil servants. It paves the way for a future where the lines between state and ideology blur further. Last month, Justice Chitta Ranjan Dash joined the RSS upon retirement. While judges are not bound by the same rules as civil servants, this trend raises questions about the independence of the judiciary. The Madhya Pradesh High Court's judgment is a watershed moment, but not necessarily for the right reasons. By lifting the ban on the RSS, it risks eroding the neutrality of civil servants and, by extension, the trust of the public in unbiased governance. Thank you for watching. If you found this analysis insightful, don't forget to like, share, and subscribe for more deep dives into India's pressing issues.